All right, well, we're back from the break now. And before we start with our panel for this section of it, we have some questions from before. These are questions that came from the various remote locations, and want to encourage people to keep sending those questions in. Any questions that are here can be written out and given, and we will present them as time allows. But Michelle, you had a specific question that was directed to you, and do you want to read the question and answer it?
The question was, when there's an instance when a client comes in and time is of the essence, such as a HEMAP appeal, and we have this referral process to send it over to an attorney, what would we do? Because the attorney may not have time to really get to that, since they have a limited time for the appeal. That was the question. And I'll answer it in two ways. In Philadelphia, we have another entity that receives separate funding specifically to do HEMAP appeals that takes emergency walk-ins. So that would be probably the next, the next step. But outside of that, what we would do is tell the client that they have a right to appeal. They have to appeal on their own because we can't assist them with that. But to get it in, and then the attorney would have an opportunity to respond to that, to review it and then assist in the appeal by the time they actually have the hearing.
And can I add something to that as well?
Absolutely.
A HEMAP appeal is effected when the homeowner sends a letter, and the letter has to be sent within 10 days of the notice of denial. But the homeowner doesn't have to do anything fancier than a simple letter saying, I appeal. So that can be done very quickly by the homeowner. The assistance with the details of the appeal can be provided before the hearing date and during the hearing, which is usually done by phone.
And if I could add one more thing.
I knew you would.
The funds available under this grant won't be able to be used to in a sense, represent folks against us in an appeal. Okay, now, if you have other available funds, either pro bono, or if you have if a legal service client who's eligible for legal services, then you have other funds to use. Okay, so that caveat. Mm-hmm. Okay. Now, the other thing, I'm sorry, you done, Michelle?
No. That's it, John. You're the end of the note.
And I'm just going to add briefly to that. If it wasn't a situation that couldn't be handled under this project, remember this book has the contact people for each program. So if there is something requiring immediate attention, there is a name of somebody that can be emailed or called to try to immediately deal with whatever that question may be. So don't feel stymied to be able to make that contact.
Now, Sam, you had a couple of questions you were going to deal with.
Yeah, there are two questions that came to me. One is, what is Act 91? And I think we mentioned Act 91 in the opening session. I'm not going to try to speak to that, but I do want to say it is on the agenda as part of the content for this afternoon, so stay tuned on that. The other question that was asked was, if a legal aid program determines they cannot advise someone because of a conflict, do they still do a full eligibility determination and referral, or do they only tell the person they can't represent them and give them a phone number? And it is, I suggest, not appropriate to do a full eligibility determination if somebody has determined that there's a conflict. That program then shouldn't be learning things like what their income might be or who's living in their home or things like that. So they should not conduct a full eligibility determination. What they should instead do is just immediately give them the phone number, give them the contact number, somebody to refer to. And I've made this offer, and I'll make the offer again now because I don't think we're going to deal with this very often. But please feel free to give me a call, and I will personally assist if there's a question about how to deal with a referral in a conflict situation. Hopefully it will be pretty smooth.
All right, and thank you, Sam. We have been getting some other questions in, and I'm actually going to turn the program over to John now, who you met earlier today. And John's going to do one of the questions that we received from our Bethlehem satellite before he begins going through the program. We have a second question, and that may be answered by the panel now or may be answered later. So if you're from Bethlehem and your question doesn't get answered, don't fret. We will get to it before the end of the day. At the end of the day, we may run out of time, and you'll have to be looking for email responses. All right, John, welcome, and the program is yours.
All right, thank you. One thing I wanted to mention is follow up on what David mentioned earlier, that in terms of the client who wins the lottery. Unusual as it may seem, these funds that are available under this grant, there are no income limits. So it's possible that you do have a lottery winner that you can continue representing because unlike most of your legal service clients, we have income limits and so forth. These funds, there is no limit. So you'll be, for a lot of you legal service folks and pro bono folks, you are representing people who you may not have represented before. They are still eligible to use these grant funds for that $500 worth of service. So it's an unusual situation. On our panel here today, we have a large number of years of experience. And they'll introduce themselves, but I've dealt with all three people, Patrick Cicero, Beth Goodell, and Mike McKeever, many, many times over the years. It's unusual to have a panel that's made up of both legal services attorneys and an attorney who brings foreclosure actions. But actually, he's a good guy.
And why I'm on a panel called Avoiding Foreclosures when it's my practice, I don't know, but I'll give it a shot. Thanks.
But Mike has been very active over the last many months in helping to actually stave foreclosures, helping Philadelphia's program of loss mitigation and conciliation, helping to make that program work, helping other counties, Dauphin County, Allegheny County, come up with a program that works. So he's been devoting a lot of his time pro bono to those kinds of issues. I think Mike's going to go first. Mike McKeever, who's a partner with the firm of Goldbeck, McCafferty, and McKeever in Philadelphia.
Thank you, John. And thank you for the opportunity to present the lender's perspective on loss mitigation. It is an issue that has taken on increased importance, but for lenders, it's always been an issue. And they use the term loss mitigation because that's what their perspective is. How do we reduce our loss? How do we mitigate our loss? Because every foreclosure results in a loss. Some estimates are as high as $100 to $150 per day for every loan. Every day a loan is in foreclosure. Other estimates, and this was before the current economic crisis, would peg the loss at $30,000 to $50,000 per property. I would guess with declining property values and the ballooning loan balances that we've experienced, that your losses, in retrospect, we're going to be seeing losses in the $100,000 to $150,000 range in certain geographical areas. So everybody says, well, if the lender's going to lose all that money, why are they foreclosing when there's this offer on the table or a simple loan modification is sitting out there ready to be taken? And I could give you an overview. In fact, I'll give you a brief overview of the securitization market because I think it's important. And you'll hear a lot about this in your practices if you're taking these cases. The securitization market the mortgage securitization market is the investment vehicle that has been created many years ago, which has provided very liquid and intense amount of capital to fund real estate purchases throughout the United States, and it's been duplicated in other countries as well. It's a tremendous advance, but it has some downfalls. The advance has been is that it's taken the risk of interest rate fluctuations and localized issues such as a plant closing down and taking that interest rate risk and that loan risk off of that local bank and shifted it to a larger class of investors. And those investors buy mortgage-backed securities, and they have an expectation of return on those mortgage-backed securities. But they're investors. It's an amorphous group in many cases. It may be held. It's always held by a trustee, and a trustee can make some decisions on behalf of the investment trust, but they can't make all the decisions, and they certainly can't reduce loan balances for every loan in the trust or even a significant portion, because that trustee has a fiduciary duty to all of the investors. And then there's generally 2 or 3 classes of investors as well. You hear them described as tranches. In fact, I was just reading an article about the tranche warfare that's starting to impact the mortgage securitization market, where the holder of the first tranche is the A piece. They get the best return. They get the money first. And then there's a B and C piece, and sometimes there's subsets of those. So if a lender I should say a mortgage servicer, since the majority of payments collected in America today are collected by a mortgage servicing company, that is usually not the holder of the note and mortgage. They're just a servicer. They collect the payments, they pay the taxes, they pay the insurance, they keep the books. That mortgage servicer is generally doesn't have the total control over the investment trust and have to go oftentimes to the trustee to ask for guidance on whether or not modifications can be made to the trust. Okay? They do have some leeway under the pooling and servicing agreements, and we'll be talking about them as we go along today. But it's not substantial. And in this day and age, as the number of defaults went up and the properties, more and more properties went underwater, that is, they're owed more on it than the property is worth, it made the servicer's ability to modify those trusts much more difficult. Specifically, they generally limit it to the percentage amount that they can change on the trust without violating the terms of the trust. And I'll tell you what happens when a servicer goes beyond their contractual duties. They have to buy that loan out of the pool. They have to buy the loan from that investor for 100 cents on the dollar for everything that's owed on it. So even if that property is worth $50,000 and the debt is $200,000, that servicer, if they make a mistake, has to buy that loan from that investor. So when you hear that the investor won't approve the loan and you wonder why that servicer doesn't just do it themselves, it's because it's impossible for them to do it. If they bought out every loan out of the pool there, the investor said no, you would just simply bankrupt another set of companies that our taxpayer dollars would have to go to bail out. So it's a careful weighing process. So that's a little bit of a background, and I'm sure Beth and Patrick will have some things to offer on servicers and trustees and investors. But that is the dynamic that many servicers find themselves in at this point in time. Of the loans in America, about somewhere between 80 to 90% of the mortgage loans in America are held by an investment trust. When you hear that a bank has put a moratorium on their loans or loans that they own, you can pretty much be assured that that's about 10 to 15% of the total loans that they are servicing, just based on the fact that 80 to 90% are held by an investment trust. And that's been a big issue with all the moratoria that have been introduced by various banks and lenders. So you may have somebody who comes in and let's just say that J.P. Morgan Chase has said we're going to put a moratorium on our foreclosures. And that person comes in and they got a statement, it's a Chase statement, and they pay their mortgage to Chase, but there's no moratorium. The foreclosure's proceeding. It is probably due to the fact that that loan is not held by Chase as a corporate entity, that it's owned by some other investment trust, and Chase is simply servicing the loan. So I think with that background, I'll briefly describe the various foreclosure alternatives, if you will. There's payment plans, which is an element of forbearance. There's flat-out forbearance, loan modifications, partial claims or advanced claims, of course, refinance, full payoff, full reinstatement, short payoff, and something that I call short refinance, and I'll explain to you what that is when we get to it.
If you look at page 61 in your materials, there are written summaries of these options as well.
And I should point out that in Pennsylvania we have an additional option, which of course is the HEMAP program, the Homeowners Emergency Mortgage Assistance Program, which is triggered by the filing of application after the Act 91 letter is sent. I will say, and it's not just because John is up here on the panel, but knowing what I know about national programs in general having done a number of these seminars even across the country, I can tell you that HEMAP is probably the single most effective foreclosure avoidance program in the country. And every state would be well advised to replicate the program. The last I looked, something along the lines of about 80% of the borrowers who get HEMAP assistance never go back into foreclosure. And I think I think it's actually probably a little bit more. And that's a pretty impressive statistic. Now, on the other hand, they also take the best borrowers out there, the best homeowners, the one most likely to resume making payments. But nonetheless, in the way it's done, in the time frame in which it's done, which is really at most a 90-day period, perhaps longer with an appeal, the lender receives a full reinstatement. PHFA ends up taking a second loan out on the property, and most of those loans are repaid at some point in time. In any event, the other options that are available is forbearance. Forbearance is one aspect of forbearance is a flat out the lender agreeing, and I really should be careful, it's really the servicer, but we'll interchange those today. The lender or servicer agreeing that they will simply not proceed with any sort of foreclosure activity for a period of time. And that may be because, and it's almost always related to some specific event in a person's life that is of a temporary duration. And, you know, I don't see lenders do this on a long-term basis other than for a month or two, and generally related to serious disability, medical condition, or death of one of the borrowers or someone in the household. So that's just a forbearance. No money is paid on a month-to-month basis. It just kind of accumulates for 2 or 3 months before the resumption of collection activity or repayment of the amounts due. An element of forbearance would be a payment plan, where because of a temporary setback, the lender and borrower agree, the lender and the homeowner agree, you know, let's reduce the monthly, well, you haven't paid for a few months, so let's look at either an upfront lump sum payment and then a little bit more each month on top of your monthly payment. Or payment plans could also be, let's reduce your payments for a period of time and then revert to the normal payment schedule with an additional amount to cure that default. Oftentimes with a lender and a homeowner in a pre-foreclosure situation, this is done by a letter agreement among the parties. The parties discuss it over the phone, over a course of conversation, and then the lender sends out a letter that says, here's what we want you to do. And if you make this payment by this date, you know, we'll not proceed with foreclosure. We'll forbear from foreclosure at this point. If it's in the context of a pending foreclosure process, oftentimes either attorney for the lender will be asked to prepare a payment stipulation plan that's incorporated into a consent order or consent judgment that's effective if the homeowner defaults in payments. That, of course, should be reviewed carefully by an attorney and appropriate comments made before a homeowner executes those. A fair number of lenders do not use their legal counsel to prepare those agreements. And again, I would caution you as a practitioner, or I would caution you initially, there's a lot of conversation going on between the lender and that homeowner that we're not always aware of. And I mean all of us who do this, whether you're a pro bono counsel, housing counselor, legal aid attorney, or the attorney for the lender itself. There's constant conversation that is going on. And you have to make sure before your client signs that agreement that they know to bring it to you. And I will also highlight this issue. There are oftentimes very tight deadlines from the lender to that homeowner that the homeowner has to comply with. We hear a lot of complaints about that, and let me just, the basic reason that there are tight timelines is because the payment schedule has been set up based upon a date in which it's going to start. And usually there's a timing issue of, well, you know, we're sending this out to you on the 23rd, the payments start on the 1st. We need you to turn it around and overnight us a check by this date. I'll leave you all to decide how you handle that on your case-by-case basis if your client's not able to do that. The review obviously needs some time, but the payments that are negotiated are negotiated. So if that homeowner then comes to you and says, hey, I don't have that money, there's something wrong there, because generally that lender has negotiated and written up the payment plan and had gotten it approved based upon what was represented to them in the negotiations. So that may trigger a reworking of the entire agreement or denial of the agreement or some other things. And remember, the servicer has to work oftentimes up the chain, not only within their own company, but also with the trustee or the investor on the loan. So it may not seem like 3 more days is a big deal, but 3 more days is a big deal because it triggers these other events. That's a little bit of the perspective from the lenders on deadlines. Loan modifications. Loan modifications are becoming much more, well, they're used with much greater numbers at this point in time than they were even just a year ago. However, principal reductions and substantial long-term reductions in interest are not occurring across the board. You will see them especially in more higher cost loans where the interest rate was pretty high to begin with and the lender has more flexibility. But oftentimes what is being provided is a period of time to resume payments at a level that's affordable. But at some point in time, the interest rate often will step back up to either a market adjustment or a fixed rate that the parties agree upon at that point. You're not seeing a lot of principal reduction, although there's a huge push for that right now. And again, it relates to the investment expectation. And any of you who have gotten your year-end statements, if you have a 401k or a pension plan, you know that I think in America today, I think most people, I think the average loss was 30% of your investment income was reduced in 2008. I would tell you if wholesale modifications were available, you probably would have had a 130% loss in your investment accounts. And it's because all of your investment accounts have some portion of mortgage securitizations in them. So we have to be careful about wholesale changes to loans and loan pools because it has this slippery slope kind of effect on the entire investment community. So loan modifications are available, and I think there's three main things that can be reduced. One is simply reducing things like property inspections, late charges, attorney's fees and costs to the extent that they've been incurred. That sometimes is negotiable with the lender. The other reduction would be an interest rate, and again, most what we see is a reduction of the interest rate to a lower fixed rate for a period of time. We see, and then a step up in 3, 4, 5 years. And then finally a reduction in the principal balance. And there's oftentimes a forgiveness of the underlying interest that's been accrued. Sometimes the lender will take that interest rate reduction and retroactively apply back to the time of default. So, and that's where you'll see the interest be reduced. So those are some of the available loan modification techniques. In my opinion, loan modifications are the most difficult things to get from a lender. And that's based on my experience in working these loans and loans in foreclosure. I think they're the most difficult to get. I think when you're dealing with, again, the high interest rate loans, you probably will find a lender who's a little bit more flexible in reducing those. But in fixed rate products under 8 or 9%, you're not going to see lenders make substantial reductions to the interest rate. They again may make some reductions elsewhere. And what we'll talk about later, and especially in the litigation section or in the review section at the end about documents and predatory lending, et cetera, there may be elements of the origination that impact what the lender is willing to do in modification terms. The other claims, the other option would be a partial or advanced claim. Partial claims is a term of art for HUD loans, FHA-insured mortgages. And partial claim, what that really means is it's actually very similar to a HEMAP loan, but it's available only on HUD loans. Actually, Fannie Mae and Freddie Mac have come out with similar claims as well. And what this allows the homeowner to do is to provide, again, to provide the financial information required by the lender. And that financial information is pretty standard. Your monthly income and expenses with some backup detail. Pay stubs, utility bills, especially if they're substantial, car bills and proof of insurance and that sort of thing, or cost of insurance. Those are pretty standard documentation requirements. What the partial claim and the Fannie Mae product do is essentially provide to that homeowner enough funds to bring their account current in exchange for signing a secondary note or mortgage at a very low interest rate. The Fannie program offers a 5% fixed rate for 15 years. The first 6 months you do not pay on that second note, and after 6 months the average payment would be at about $30 to $50 a month, because the max that they will lend is $15,000. So if you've got somebody whose reinstatement amount, that is the amount to bring current, is under $15,000, Fannie or Freddie, which has a similar program, you may want to look at an advance, what Fannie Mae calls a home saver advance.
Mike, could I interject here with an important point? How do you know if a loan is Fannie Mae or Freddie Mac backed mortgage security or in their own portfolio?
Yeah, it's not always easy to tell. The loan documents themselves, every loan document, almost every loan document that you will see will have at the bottom Fannie Mae, Freddie Mac standard single-family instrument. But that doesn't mean that the loan itself is a Fannie Mae or Freddie Mac insured loan. Sometimes you can deduct it from looking at the loan documents that may have some Fannie Mae or Freddie Mac endorsement or language or number. That's not a guarantee. The only guarantee you really have is to get it from your servicer. I understand that some servicers may not, that will say that for reasons of confidentiality we can't release that. I would think, especially in light of the Fannie and Freddie announcements and their more proactive stance these days, that lenders would provide that information. And certainly in the conversation of loss mitigation and home retention, I know that my lender clients are proactively looking at Fannie and Freddie loans and reaching out to those borrowers and identifying those loans as Fannie Mae or Freddie Mac loans.
Another question along that line, Mike. What percentage of loans are Fannie or Freddie backed? In other words, what's the likelihood that any one of our clients might have a Fannie or Freddie loan?
Fannie and Freddie, even before, well, from 2008 and before, probably did about 40 to 50% of the loans in America, and you know, these would be non-FHA or non-VA. Although there's some little products that are in that boat, but I don't want to bore you with those details. But you have a pretty good shot that it's Fannie Mae or Freddie Mac. What happened actually in 06 and 07, and part of the growth of conventional lenders is that Fannie Mae and Freddie Mac's share of the mortgage market did decrease in 05, 6, and 7. But even with that, they're still at about 50%. And where you would see that, I don't know all the names of all the conventional lenders, but I think you know, they're the non-bank lenders, if you will, the AmeriQuest, Option One. Those tended to be non-Fannie Mae entities. So if the loan originated with an entity such as that, it probably is not a Fannie Mae entity. It's not a guarantee, but that's one rule of thumb that we use. Generally, if it's a non-escrow loan, it's probably not a Fannie Mae loan or a Freddie Mac loan, because both of those entities generally required escrow as a portion of the payment. So, So the partial claim, which is offered on HUD loans, is very similar. Again, there's a tremendous paperwork requirement there and a lot of intense negotiation between the servicer and the homeowner. If I could leave anybody with anything today, I think that intense paperwork is really the key to a successful loan resolution. The gathering of the financial information from the homeowner, the constant updating that may be required, the passage of time from the initial submission until the lender is then close to making a determination may trigger by the lender a request for updated pay stubs and financial information, et cetera. It is a constant paper battle, but it's one of the things I've learned in doing the diversion programs and the other home retention programs that we've done. In fact, I had a counselor come up to us last week and said, boy, this process works so much easier when my client has given me all the financial information I need. It just works so much easier. You're not going to know everything every lender wants, and even if you use a standard Fannie Mae or Freddie Mac form, they may have additional information that they would like. But I think you're wise to look at things like current pay stubs, last couple of years of tax returns, and again, the utility bills and financial information such as that. If somebody has a large lien for child support, you need to get that. They need to get you that documentation, and you need to be able to provide that. Any other liens or encumbrances out there that they have to pay for other state or governmental entities, you should have that information readily available. If it's a non-escrow loan and they've worked out a deal with the government, the taxing authority to pay their taxes over a period of time, the lender needs to see that documentation. So the other options in resolving a loan are a refinance, of course, which would go to a new lender, provide loan documentation, and assume you have some equity in the property, and that would require equity. Full payoff, that's easy to explain. I think everybody would know that a full payoff of the loan would be an acceptable remedy for the lender. A short payoff. We hear a lot about short payoffs now because property values have dropped. Short payoffs are the lender will agree to accept a certain dollar amount in exchange for release of the mortgage lien as to the property. Generally, that means a release of the note obligation as well, although sometimes a lender may say, I'm forgiving $80,000 worth of debt, but I want you to sign this note for $10,000 of that, and it's an unsecured note. Sometimes you'll see that in a short payoff situation. Short payoff requires all that financial documentation plus an agreement of sale and with a firm closing date. Generally, lenders will not agree to a short payoff where it's an interfamily transfer. So you're cautioned with that. I mean, obviously they don't want, they want to prevent moral hazard. That is creating a situation where everybody gets to be able to reduce their mortgage through that vehicle. And finally, the short refinance. Although this holds a lot of promise, unfortunately, because of those investor constraints that we talked about earlier, short refinances would be very difficult. That is, it's a payoff of the loan, but at a lesser amount than what's due and owing on the loan at this time. Similar to a short payoff, but it's a refinancing with a new lender. Pennsylvania has the HERO program that's administered by PHFA, which essentially is a short payoff loan program. And, of course, the Hope for Homeowners program that HUD was empowered with back in July of last year, H4H, as it's known, was designed as a short payoff program. The problem with short refinance program. The problem with short refinance programs is lenders are required, that first mortgage holder is required to take basically not only reduce the property or the loan balance down to the current value of the property, but then reduce it an additional percentage as well. 80%, I think it's 80 or 85% of current loan-to-value ratio. There's not a lot of incentive for the servicer to do that. There's not a, and the investor community doesn't see a lot of incentive to do it. For that reason, the Hope for Homeowners program has not been well utilized, although there's $400 billion available to fund those loans. The last I heard, there were about 167 total approved loans nationwide in the Hope for Homeowners. And generally, probably where you're going to see that is it may be for lack of a better term, a mom and pop investor that holds the mortgage and says, well, I'll take 80% of current value because even if I took it back in and sold it and marketed it, I'm going to get 50 cents on the dollar. The larger investment community hasn't quite seen that and doesn't believe that that's a viable option for them. So it's not used very often, but you may hear it as a point of discussion. And certainly if you're dealing with a smaller lender or a privately held mortgage, that might be a vehicle that might work best for your clients out there.
All right, thank you, Mike. I just want to mention two things. Mike mentioned the requirements for HERO. In the handouts, page 95, there is a PowerPoint presentation that talks about the HERO program that PHFA has. Also, there's information there about the HEMAP program. On PHFA's website, which again is www.phfa.org, there's the Act 91 itself is there. The entire Housing Finance Agency Act is there, as well as the guidelines for the HEMAP program. So there's a lot of information on our website that you can get. There was a question that came in about what is Act 91. Go to our website. You'll see what Act 91 is. You can read it. Okay, next we have Beth Goodell, who's with Community Legal Services in Philadelphia.
Actually, I'm taking this
Oh, I'm
one,
sorry. Okay.
John. That's okay.
We don't have Beth Goodell. We have Patrick Cicero, who's with Mid-Penn Legal Services.
Thanks, John. Beth will be on. She's coming
She's
up.
shy.
Yeah. I wanted to take a little bit of time just put this back into perspective, because I sometimes forget where we are with this particular grant and this particular project, and to remind everyone that we're talking about pre-litigation activity here. So when we're talking about working with mortgage servicers and resolution of mortgage default, we're talking about before a complaint in mortgage foreclosure is filed. Or before a Chapter 13 bankruptcy has been initiated. And the reason is because the funding that is funding this is all about pre-litigation foreclosure mitigation, avoiding foreclosure happening. And so it's an important point to put in perspective and just to remind you of that's the context that we're talking about. I want to take this brief opportunity to say some of us up here and some of the other presenters on the panel are going to be presenting another session in April. There's one here in Mechanicsburg, I believe, on April 1st, and there are some other dates. Oh, you have that. Good. Pittsburgh, April 7th, and Philadelphia, April 24th. And that training is going to be geared towards litigating these cases, not for the purposes of the current grant, but for a variety of purposes for legal services and non-legal services attorneys. The actual program is called Saving the Family Home in the Subprime Mortgage Crisis Climate. And so if you're looking for specific tips to, in the context of litigation, that's a CLE that you should really, really think about attending. And Mike's going to be involved with that as well. So it's not just, a borrower's perspective. It's also going to have some lenders, attorneys involved.
And that's sponsored by the Pennsylvania Bar Institute, so you can find information on our website, and I think actually probably register on our website.
Right. Mike mentioned that it's really important to know what your servicer can do, and I want to emphasize that very, very much. We have clients come in all the time and say, I have a countrywide loan, or I have a GMAC loan. And what they mean is that's who they're making their payments to. And so maybe that's who originated their loan, or maybe not. But from the client's perspective, their mortgage company is who they're making their payments to. And it's really, really important for you as advocates, attorneys, housing counselors to put in perspective for yourself and them who the players are, who you're dealing with. And so one of the most important things that you can know is what can the servicer do. So if your client walks in with a servicing statement from GMAC or from Countrywide, you want to know what is it that the servicer can do with this loan. Because as Mike said, there's some things that servicers can readily do, and there's some things that servicers can do and they won't necessarily tell you about. But you need to know. You need to find out what it is that a servicer can do. And so in the context of pre-litigation, it's a little bit hard to know this, because I asked Mike the question of how do you know whether it's a Fannie Mae or Freddie Mac backed loan, and the importance of that is so that you can know what opportunities are available from Fannie and Freddie, but it's also important to know who the players are, and your client may or may not know that. And so when you as a housing counselor or you as a lawyer are in contact with the servicer, with the entity with whom your client identifies as the mortgage company, one of the things that you want to be asking is, who are the investors here? Who is it that actually owns this loan? I've found that in the past, servicers have been very put off by this because they don't necessarily want to tell you. So it's important to put it in the context of you're not trying to trap them, you're not trying to trick them. You just want to know who all the players are involved so you can understand and better explain to your client why you're being told certain things. For instance, if a servicer tells you, I'm sorry, our investors don't allow loan modifications, or they don't allow principal reductions, or they don't allow permanent interest rate reductions. You want to be able to, A, explain that to your client in a meaningful way, and B, check out to see whether or not it's actually the case. And so it's really important for you to know who the players are. In litigation, this becomes a little easier because you may have a foreclosure complaint that identifies who the plaintiff is, and so you can begin to piece that together. But pre-litigation, it's a little bit trickier. But in your materials, there are, beginning on page 75 of your materials, there's a PowerPoint slide that talks about critical documents. And there's only one slide there, and then the next pages are handout from the National Consumer Law Center that talks about finding, pooling, and servicing agreements. And what these are, these pooling and servicing agreements, are the master agreements which control the relationship between the mortgage originator, the trustee, the servicer, and all of the investors. And this agreement is important for a lot of different reasons. But for our purposes, one of the things that it's most important for is it generally spells out what a servicer can or can't do without investor approval. What kind of loss mitigation can the servicer do without investor approval? What can the servicer do at all? And what do they have to seek the approval for some of the tranches of investors? And so it's an incredibly complicated document. It's an incredibly long document, and oftentimes it's an incredibly obtuse document. But if you take a look at them and you can kind of parse your way through them, there is some good information in there about what your servicer can and can't do. Because the volume of these cases that housing counselors are getting, or we may be getting as referrals, I wouldn't recommend that every case you have you look at the PSA, because you're going to be going crazy. I would recommend that you look at this to the extent that a servicer tells you that they can or can't do something, because it's going to be in there whether or not they can or can't do it, for the most part. So it's really important that you know what it is that they're able to do. Stepping back a bit, that being said, it's also really important to know who to talk to. When you're calling the 800 number on your the documents your client brought in, everyone in this room, I'm sure, and everyone at the satellite places has experienced the frustration of dealing with mortgage servicers. As Mike indicated, it's really helpful when borrowers bring in all their documents and get it all together. It's also really helpful when servicers don't lose them. And that I say that a little bit in jest, but this happens. You fax documents in and they're lost. You fax documents in, they're lost. And so a measure of patience is required in dealing with mortgage servicers. And it's really important to know who you should be talking to. Don't talk to the collections folks. The collections folks are about collecting. What you need to talk to are the people who are actually interested in helping your client and the servicer's investors in restructuring this loan or coming up with some opportunity to get back into good standing. And that's the loss mitigation department or the home preservation department. Everybody, the mortgage companies have different names for this, and so, but really the loss mitigation department is the place that you should be talking to. And depending on the context with which the person comes into your office, because even though we can't do litigation and or bankruptcy under this funding, it's possible that you'll have folks who are being referred post-bankruptcy. Either they've had a failed Chapter 13 or they've had a successful Chapter 13 and they've already gotten a delinquency notice from the servicer, or they've gotten another Act 6 or Act 91 notice. And we're going to talk a little bit about that later this afternoon. I don't want to go into great detail about that. But it is possible that someone has come in post-bankruptcy, either a failed bankruptcy or a discharge bankruptcy, and they're delinquent again. If that's the case, I've found, not only in addition to talking to the loss mitigation department, but also talking to the bankruptcy department of the mortgage companies, and many mortgage companies have ombudsmen. Countrywide in particular has a bankruptcy ombudsman whose job it is to kind of resolve these disputes over fees and costs and all kinds of things. And they're very approachable. I found Countrywide's bankruptcy ombudsman department to be very approachable when I have a question about bankruptcy for a Countrywide client, even if it's post-bankruptcy, because they're going to be able to touch base with the people within Countrywide who need to be talked to. The other
lender that is Select Portfolio also has a bankruptcy ombudsman office. And I'll just want to add with what Patrick said, don't forget the lender websites as well. It's usually a great resource for home retention options. And just about every major lender has relabeled their departments the home retention department, so that should help you.
And again, because we're not in litigation, it's difficult to kind of reach out to Mike's office or some of the other foreclosure law firms. But in the context of bankruptcy, these lenders have all been represented by an attorney. And so if you can find out why their bankruptcy failed, either it's failed or it was successfully paid off, and who represented the mortgage company in that bankruptcy, and if the issue is that the fees and costs were not resolved in the context of that Chapter 13, then reaching out to the lender's attorney is also very helpful. In fact, that's the most helpful. I mean, if you can find a way to tie them in, to get them in, it's most helpful to have them involved because they're the ones who have better contacts. I don't want to say the best, but maybe better contacts at the mortgage companies to get some answers for your clients. All right. So in terms of this pre-foreclosure world, helping clients resolve their disputes, dealing with mortgage servicers, it's important to know who your servicer is, to know who to talk to, and to know who's involved. I want to say it's also really important to know your case before you call the mortgage servicer. In other words, review your client's loan documents and figure out, do an interview with your client about what it is he or she expected from this loan. Were there origination problems? Or is the problem that they're having a servicing problem? In other words, they've made their payments, but the payments aren't allocated properly, or there's some escrow problem. What is it that the problem your client's having? Not only so that you can identify it for the servicer, but also so that you can identify potential litigation claims. The reason I say that's important is because I don't, in my own practice, play hide the ball. I don't save some stuff that I'm going to spring on someone later. And so that if we get cases pre-foreclosure and I can identify some claims that are problematic for the lender, even if it's generally I think there are origination problems that make this loan unconscionable, or it's a violation of Pennsylvania's, in my opinion, a violation of Pennsylvania's UDAP law, or there's truth in lending problems. I'm going to bring that to the lender's attention up front and say, look, I know we're not in litigation yet, but these are the claims we believe that we have, and we'd like to resolve them now rather than litigating those claims. The most useful vehicle for doing that, if you have servicing problems or if there's a problem with the amount of money that is being demanded by the mortgage company, is something called a qualified written request under RESPA, the Real Estate Settlement Procedures Act. We're going to spend some time this afternoon when we talk about going through loan documents and claims and things, talking about RESPA. But I want to just point out, I jokingly told Jennifer Heverly that you're going to hear me say use a RESPA letter a lot. And that's because it's a very powerful thing to do. If you have a dispute, and let's step back. You have to have a legitimate dispute, right? Servicers get the story that we hear from servicers and mortgage companies is we're inundated with RESPA letters by people who don't have a legitimate dispute. So you should have a legitimate dispute before you start sending off these letters. But if you have a legitimate servicing dispute or a legitimate dispute about the amount of money that's owed, filing a RESPA request pre-foreclosure kind of stop things in its tracks. The mortgage servicer will investigate. They're required under federal law to investigate the dispute and provide information to you. And they're not going to proceed with foreclosure, even if they already otherwise could, until or unless they've made that response. It may not be the response that you like. It may not be a wholly satisfactory response, but they're going to make a response to you, and they're required to do it before they can proceed. And so I write fairly detailed RESPA letters where I talk about what it is that person actually disputes and what it is I've identified as some problems, and also a proposal to resolve that problem. Because if I know it, I mean, sometimes you actually legitimately need the information before you can come up with a proposal to resolve that problem. But if I know it, a proposal, that way the servicer can know that you're serious. Now, again, this all cycles back because the servicer may come back with you and say, that's all well and good, but we can't resolve that problem this way because the trust won't allow us to do it. And that's why knowing who the players are and knowing what the trust or the servicer can and can't do is fairly fundamentally important in this context. One more thing about RESPA: along with it, send in a budget, send in all your papers, show the lender what it is that your client's world is, and figure out a way that makes this loan affordable. Again, not just throwing the kitchen sink at them for the sake of doing it, but actually presenting a picture that would allow them the homeowner to meaningfully be able to afford this loan. You likely won't get everything you ask for, especially pre-foreclosure, but it's important to know all that, not only so that you can let the lender know what you've identified as the problems be, but also so you can adequately advise your clients about whether or not this is a case that actually should or should not be litigated separate and apart and independent of this project. All right. Finally, just one more point, and I'm not sure where the proper time in this day is to mention it. We keep talking about affordability. We're going to be talking about affordability, and Mike used the term that sometimes these loans aren't, sometimes modifications aren't affordable for the servicer because the servicer, if the servicer is going to buy this loan back, they have to buy it back at 100%. It's important for you to realize in pre-foreclosure what is and is not affordable for your client as well. Making promises that your client can't keep doesn't do them or the servicer or the mortgage company any good. And so as a general rule, and again, we're going to talk about some of these programs, 31 to 38% of debt-to-income ratio is what is really affordable. I mean, if you're looking at what's really affordable, that's what we're talking about. And that's why so many of these arrearage forgiveness, principal forgiveness programs are important. It saddens me to hear Mike say, and I understand why he says, that the lenders aren't looking to this. And that's why going forward, we have some hope that, I say we, meaning the legal services folks, have some hope that there'll be some changes to the bankruptcy law that would allow bankruptcy judges to modify residential mortgages to impose this. Now, what are the broader ramifications of that? I'm not exactly sure. But there is some hope that there may be some changes moving forward that would allow bankruptcy judges to modify loans. Again, we're going to get into that a little bit later in this afternoon session about what that hope might or might not look like. One final thought. I want to mention this is not in your materials, although I understand from Sam Milkus that it will be put up on the website. President Obama announced his plan to kind of save homeowners, and March 4th is when the details of that are going to come out more fully. That's Wednesday. And so on Wednesday, there are going to be much more detail about the parameters of the president's plan for home ownership retention. But just generally, that plan includes access to refinancing, allowing Fannie Mae and Freddie Mac to refinance more folks who aren't behind, who simply need some assistance. But for folks who are behind, the program is titled the Homeowner Affordability and Stability Plan. And this is a plan that, as presented in its vaguest details now, really will, for a 5-year period, reduce the rate through a combination of incentives by the lender and the government to no more than the interest rate and principal balance to no more than 31% of debt to income. Now, I want to see the details, and the details should be coming out this week, but it also provides a bunch of incentives to servicers, $1,000 upfront incentive for modifying a loan, and then $1,000 a year payments for a pay for success plan, that if the homeowner remains current, there'll be $1,000 a year payments. It provides some hope and help for homeowners to reduce the principal that they owe by allowing homeowners who actually get into this program $1,000 a year in principal reduction for this 5-year period. And so there's some hope out there. Again, March 4th is the day when the details will be released. But at least from the current administration's perspective, 31 to 35% of debt-to-income ratio is what they see as an acceptable program for going forward with loan modifications.
Well,
Now, this is, again, I want to stress, this is voluntary on the part of the lenders. None of this is something that's going to be imposed on any of the lenders and or the servicers.
Yeah, and I think, you have to keep, I think the federal government has struggled for the last year, along with the state governments as well, to figure out a plan that would really work. And I think the difficulty with this plan is they may reduce the payment amounts to affordability levels now, but there's almost, in everything I have seen, the ability of the lender later on to revisit that issue and get it back, other than in the bankruptcy cram-down context. And even there's some clawback provisions as well. And I think that speaks to the real concern of, if you start helping the 2 million people who are in foreclosure now, what about the 65 million that aren't in foreclosure who are going to say, hey, what about me? Where can I get that deal? And, and one of my concerns that, from the President's proposal is, hey, we want to help those 5 to 9 million people who are close to default but not in default yet. And that's a huge challenge right now, where you're trying to deal with as I said, the couple million that are in foreclosure that are presenting plans and negotiating with lenders. Now you've got to also, as a lender, deal with those other 5 to 9 million people calling in your call center the day after that was announced last week saying, hey, can I get that interest rate reduction? Can I get that affordability reduction? So it's a big challenge.
Well, we are about out of time on this panel, but I'm on the next panel, so I'm going to steal a little of my time from the next panel to just throw in a couple more things.
This is Beth Goodell, by the way.
I'm Beth Goodell, lawyer who does foreclosure defense and bankruptcy work at Community Legal Services of Philadelphia. This panel has primarily been about know what's in your toolbox, know what the options are for any given homeowner client of yours. On page 79 in your materials, there is a web link to the National Consumer Law Center. It's a site that's updated regularly with information on what the various servicers are able to provide by way of loan modification and other programs. It also gives information on the options available to borrowers whose banks, the lender or servicer of their loan failed when the FDIC took it over. So there's some information there about dealing with loans that are now come under the FDIC's jurisdiction. And that's a site that's regularly updated. Then after that page, on page 81, for the several continuing pages, are information at the moment on several different lenders and servicers programs, including references to the countrywide settlement with the Pennsylvania Attorney General. So you can look to these resources to help you know what the details are for any particular client. A couple of other points. I mean, those of us who do foreclosure defense have a sense that it's very hard to get good deals for our clients before foreclosure has started. It's often the case that you have more leverage after a foreclosure is filed and you're defending it. So know for your clients who you're working with pre-foreclosure, which ones are you going to realistically be able to represent if a foreclosure case is filed, because the way you think about the resolution changes if you believe you're going to be able to represent that client in the foreclosure. One point we didn't mention, very practical, know the value of the house. And I find that in working with housing counselors who are often in the neighborhood where the homeowner lives as opposed to where I am, and if I can't get that information online, the counselor will have a sense of what the house is worth. If you have access to online services for giving you a good sense of what property values are, make use of those. It's a key negotiating point to know the value of the house. If the house is worth significantly less than the loan amount, you should be putting that in your correspondence with the loan company. If it looks like the house is significantly lower value than the loan amount, ask your client to pay for an appraisal. Get a written statement of the value of the house so you can send that to the lender to set the conversation about the resolution realistically from the beginning. Get your client to save dollars if you can during the course of the negotiation. The pre-foreclosure negotiations may not go on for very long because the foreclosure may be filed if you can't get a quick resolution. But if it goes into foreclosure, and this is saying what we all know really, urge your client to set aside, with your office if possible, if you can do a savings for your client, to set aside the amount of the monthly mortgage payment every month. It will help enormously at the point where you are doing a negotiation with the lender. Find out, and we're going to talk about the importance of this when we're discussing the Fair Debt Collection Practices Act as well as RESPA. Find out if servicing of the loan changed while the loan account was in default. Get a sense of the history from your client of who was servicing this loan at various stages, because there might have been a prior default and then servicing changed. Often servicing will change to a default servicer once the loan has been in default for a considerable time. This may or may not happen with somebody who's just recently in default for the first time, but it's useful to know if the current servicer acquired the account while it was already in default, and we will talk more about why later on. Can we open up for questions, or should we wait till we are past?
Any questions on what we've covered so far in this segment? There's one in the back, yes. And if you could go to a microphone, that'd be great. Because while we could probably hear you, then the people in the other locations won't be able to. As she's approaching the microphone, the other comment I would like to throw out there is, if it is an FHA loan, as Mike said, you can identify it as an FHA loan, and if there's irregularities with respect to servicing of that loan, or even more importantly, in the origination of the loan, let's say you think there was fraud, that there was a mortgage broker inflating values, that sort of thing, HUD is a very good place to make a complaint to, the regional HUD office. In Pennsylvania, the HUD offices have been working very closely with the U.S. Attorney's offices, and there have been prosecutions brought in all over Pennsylvania where it's been obvious cases of fraud, especially where it's been widespread fraud. And as evidenced by the countrywide case, the Pennsylvania Attorney General as well, who was a U.S. attorney at one time, has become actively involved in the subject as well. Any question?
And I would just, if I could, John, just to follow up on that, don't think that those go unanswered. It may not result in an immediate reaction, but especially with appraiser or broker fraud, HUD and the FBI do track those. They have to reach a certain level, I think, before they take action all the time. But certainly it's helpful for them to kind of identify the target area, if you will. I'm sorry. Go right ahead.
Yes, I'm interested in this question because this past week I had two clients who came in who had already had judgments on their foreclosures. And in speaking with the clients, they had been in some sort of workout programs with the lender. And in both cases, both of these clients claimed never to have gotten an Act 91 notice. Whether that's accurate or not, I'm really not sure. But my question is, what workout options are available prior to the complaints being filed and after? Is there any significance to what their options are pre and post complaint?
There shouldn't be a difference in the options that are available. What you might have when there's a foreclosure in process and you're defending it is a bit more leverage to achieve principal reduction, interest rate reductions that are more dramatic than you might be able to achieve pre-foreclosure. And and Mike can speak to how the mortgage servicers make these determinations, but my sense is I've been able to get better agreements if it's in foreclosure and if it's defended with a good defense. And I don't know if that's a practical issue, if there's a way to access those better resolutions pre-foreclosure.
I think Beth is right. I think the more issues that are real and that are presented to the servicer, the more likely that that servicer will make some reductions or take a look at that account and see if there's some other way to resolve it. I do want to go back to that first issue you raised. It's almost impossible to file a foreclosure action in Pennsylvania without the Act 91 being attached. And the attorney who files it has to certify that both at the time the complaint is filed and then later, before judgment's entered and a sale is scheduled, they certify to the sheriff that the Act 91 had been sent. So it could be that it's an FHA loan, or it could be that the homeowner who's inundated with mail just didn't know the Act 91 from a demand or a collection notice or the solicitation from the bankruptcy attorney. So, but every foreclosure complaint, if the Act 91 applies, should have a copy of the Act 91 letter attached.
Well, these cases were unusual in the fact that this is the first time I really had clients who had come to me and had actually been doing workouts on their own. And since they did, in fact, say that they didn't get the Act 91 notice, apparently what they must have done then was just contact the lender directly and been trying to do some workout agreements. If they had a forbearance, the one client did say she had a forbearance agreement. Should she, in fact, then have a contract that she can bring into me that I can look at it? Because she also stated that the last payment she had mailed in was for $2,500, and she thought she was, still in good stead, and then turned out that they told her, well, no, we filed a judgment because that last $2,500, that all went to the attorney's fees. So none of that went to her.
We're going to address servicing issues in a panel this afternoon, and what in some ways what you're talking about are servicing issues too, about application of payments and whether or not it was clear that a forbearance agreement what the payment was for, and so we are going to address some servicing issues later this afternoon. One thing I specifically neglected to mention is that the Truth in Lending Act does require the servicer to identify who owns the note. And so when I was talking about it's difficult to get this information out of servicers, it is difficult to get the information out of them. The Truth in Lending Act does require them to identify who owns the loan. And so usually what you'll get back from them is either in response to that, they'll say, I don't know whether that's true or not, what you're telling me, but if you put that in your RESPA demand, that you're demanding proof of ownership of the note and mortgage under Truth in Lending, they'll at least identify the trust who's responsible for the pooling and servicing of that loan, which will allow you to access the pooling and servicing agreement.
Patrick, thank you. We're going to make our transition now. We're going to get rid of Patrick and Michael and add Michelle back to the panel. Seems like a perfectly fair trade. And what we're going to do, just so everybody on the satellite sites understands, we're going to move seamlessly, as Beth had mentioned, into the next session, which is on the loan documents, and we will end on time at lunch. If you take a look at me, we don't miss lunch. But the purpose of our lunches, especially at the satellite sites, is to provide that networking opportunity with the lawyers and the housing counselors. And so we're going to make absolutely sure that this panel ends at 12:15. So without further ado, John, the panel is back to you. Thank you.
Okay, thank you. I think that Beth Goodell's going to lead off. Is that right, Beth? You're going to lead off? Okay, let's get right to it. So again, we can get done promptly in time for lunch.
For those of you who haven't done many mortgage cases, this will be an important session. For those of you who've been doing it for a while and are looking for new information, not so much. I'm going to go over loan documents. The sample documents that we've included in the materials start at page 109. And I'm going to look at each of these documents, give a little information about what to look for, what information can you get out of them to help you understand the nature of the loan that you're dealing with a special eye to those loans that are what we would call predatory subprime loans. This current mortgage foreclosure crisis was fueled primarily by the high rate of bad loans that were made over the last decade. It created a house of cards that's collapsed, and you should understand understand the information about the loan, especially if it's a predatory subprime loan. Where do you get documents to start with? Hopefully your client will bring to you, or will have brought to the housing counselor in the context of this program, the documents that they were given at the loan closing. They should have been given a thick set of documents, a copy of each document that they signed, and some documents that didn't require signatures at the loan closing. So the first effort to get copies of the loan origination documents would be to ask the client. Clients don't always have them, and if you're missing some key documents, another way to get them is a qualified written request under RESPA, and Michelle is going to talk in more detail about RESPA and what it gives you. But a qualified written request to the servicer should be able to get you copies of the loan documents, the most essential loan documents. Now, the trouble with timing, of course, if you are trying to get something done for your client pre-foreclosure and you can't get the information back quickly enough from the servicer, you may be in foreclosure by the time you get them back. If you're in foreclosure, you get them through discovery. If you're representing a client in foreclosure, you can ask for the documents in discovery. Another relatively quick way of getting them would be to ask the title company. If you at least have or can get online a copy of the mortgage. And at this point I want to say that it's very helpful to have online access to your county's publicly recorded real estate documents. In Philadelphia, it's pretty easy. You go online, you go right into the service that pulls up a copy of the document as a PDF right out of the county's records, and you can print it out, and you have that actual document with a signature on it, with the signatures on it, because often your client will have a set of copies that don't have signatures. So you can get the mortgage online as recorded. It's often stamped with the name of the title company, the closing company, after recording, return to so-and-so company. And you can use that information to contact the closing agent, the title agent, and ask for a set of the loan documents. So those are a couple.
If I could, more and more counties, too, are online.
Mm-hmm.
Dauphin
Yeah.
County, for example, the Recorder of Deeds office, you can go there free of charge and get a copy of the mortgage, et cetera. And more counties are going to that kind of a system.
And what you can get from the public records is a copy of the mortgage and the deed if you have issues related to the deed.
And assignments, too.
And assignments of mortgage. But you can't get a copy of the note, a copy of the settlement statement, a copy of the loan application. For that, again, if you get a copy of the recorded mortgage, see who the closing agent was, contact the closing agent, and see if you can get copies of loan documents from there. The materials have some in a couple of different places. There are descriptions of different components of loan documents, descriptions of what a note is, what a deed is, and different types of loans like fixed rate, adjustable rate. Page 297 of your documents is a pretty useful section for just a summary of these terms. As I look at the loan documents, I will point out where you see that it's a fixed rate or an adjustable rate. I'm not going to talk a lot about what the definition of those terms are. So when you have a chance, if you're new to this, take a look at page 297 and beyond. On page 109 of the documents is a loan application form. The loan application that is signed at the closing of a loan is usually, is I would say never, the very first version of a loan application. The final loan application, the lender and the broker, if there was a broker involved, would have set up to match the terms of the loan. So it may not be, it won't likely tell the full story of what the client thought he or she was getting or what they'd asked for in the loan. But the final version of the application will at least give you what the lender had in its records as the final take on what the household income was, what the interest rate the homeowner was applying for, the amount of the loan, and those details. It's very helpful if you can get earlier versions, but in my experience, I don't get those unless I'm litigating and I've sent a discovery request for the whole loan origination file. But the final version of the loan application, hopefully your client has it. If he or she doesn't, then the settlement agent has to. So looking at this loan application, this application and some of these other documents came from a transaction that we're going to discuss later because it was a predatory loan with some pretty mind-boggling twists and turns. But if you look at the second page of that loan application, up at the top, and again, this is a uniform application, so whatever loan you're looking at, the application should have this information in the same place. The top of the second page is the information for the household income on the left side. And in this case, the application was filled out to represent that there was $2,833 on behalf of one of the borrowers, and then another $1,500 for total household income of $4,333. That's what's represented on the form. We'll talk later about the fact that that wasn't true. Over to the right, and this is a very interesting section on loan applications, there's space for the house payment that the borrowers currently have, their present payment. Now, some of these, the type isn't as readable now, but over to the right at the top of that second page, it's the word present for the present house payment. And the application should show what the principal and interest payment is, what the tax payment is, what the insurance payment is, so you can see what the homeowner had before they got this loan. And then at the far right, up there at the top, is the proposed. What's the new mortgage payment going to be? And there's similarly a space for principal and interest, taxes, and insurance. And then down at the bottom, the total payment that's being proposed under this current loan. And in this example, that number is $501.94, just to so you can see where I'm looking. Down at the bottom left, there's the value of the real estate, and in this case, it's $126,000. Now, for cases where you think that there's been an inflation of the value of the house in order to make a loan go through, you can see here what the loan was targeting, what the supposed value of the house was. On the next page, and this is page 111 of your materials, there's a statement of the amounts that are owed that are going to have to be paid through the loan. That's line D in the sort of middle section of that page. So the amount of debts that are going to be refinanced, if any, plus the fees that are going to be added in the loan, and then in line, I think that's H, the loan amount, in this case $87,500. Loan applications are especially useful for the representations about the borrower's income, the payment that they thought they were going to get, and what their payment was previously. The next document on page 112 is a good faith estimate. It's a document that is required by the Real Estate Settlement Procedures Act. It must be sent to the homeowner before the loan closing, very shortly after the application, in fact, to give the homeowner a decent idea of what fees are going to be included in the loan. There are no legal penalties to not having it be good faith or a realistic estimate. The numbers can change dramatically, and if they did, and if your client actually relied on these representations before closing, then you might have an unfair trade practice of deception or fraud claim, but there's no cause of action related to not having this form done in good faith or realistically representing what the closing costs are going to be. In bad subprime loans, I've seen many cases where the good faith estimate did not correspond to what the fees and costs were in the end. The next document on page 113, it's a sample settlement statement, also known as the HUD-1. This is the gold mine. This is the one piece of paper I'd most like to have when I'm analyzing the loan of a client or a potential client. It should show where all the money went. And if you're, the key to understanding if a loan is a predatory loan and in what ways it might be is to have the settlement statement. Hopefully your client has it. If not, again, try the settlement company. We're going to talk more about this particular settlement statement when we get to the section on predatory lending and truth in lending claims. And I have a couple other samples that I want to show you towards the end of this section. But as you look it over quickly, you see that on the front and back, it breaks down pretty much every penny of the loan amount. The next document, page 115, is the first page of a mortgage. You can see up at the top the information I was referring to, when recorded mail to, and it says diversified settlement services. So this is an example of a mortgage document as recorded that we were able to pull out of the public records. So it has this information about this servicing company, the settlement company that you might contact to get copies of the loan documents. The mortgage itself doesn't tell you as much information as the note or the settlement statement or the application. It will identify for you the name of the lender, although in this day and age, it might also tell you that a company called MERS, Mortgage Electronic Registration System, is also in the mix. Mortgages where MERS is involved will identify the lender, and then will identify MERS as a nominee for the lender who is also the mortgagee. And there's a whole set of issues related to when MERS is in the mix that may be useful as a foreclosure defense, but doesn't help so much in negotiating a resolution pre-foreclosure. The mortgage can also tell you the amount of the debt, and in this sample it's $88,825. But for really understanding the terms of the loan, you need the note. The next page, page 117, is a sample adjustable rate note. There are a lot of adjustable rate loans. That's another part of what's fueling the current foreclosure crisis. Subprime loans generally were adjustable rate loans. There are some non-subprime loans, non-predatory loans that are adjustable rate mortgages, but a lot of them that you will see were subprime adjustable rates. The terms of the adjustable rate will often come in a rider to the mortgage, which will be recorded. So if your client doesn't have these documents, you might be able to get the terms of the loan with the recorded mortgage as the adjustable rate rider at the very end of the recorded document. Otherwise, the terms of the note are included in the note contract, which hopefully your client has. The sample here is cut up a bit. We left out a lot of paragraphs so that paragraph 4 regarding the interest rate and monthly payment changes is right here on the page in the materials. This is where you want to look to understand the terms of the adjustable rate. The information about the rate starts out with the base rate. And that's actually just above the paragraph 4 on this document, where it says the note provides for an initial rate of 8.65. So there's your initial rate. Then under paragraph 4, the change dates, 4A, the change dates, it tells you that this loan is going to have its first change in April of '07. The loan date, which you can see up at the top of the this rider, was March of '05. So this is an adjustable rate. The rate holds for 2 years and then adjusts. The adjustment is based on the index and a margin that's going to be added to the index. Paragraph 4B defines the index that's going to be used after that first 2-year period to calculate the new interest rate. Many subprime adjustable rate loans are tied to the LIBOR rate. and I won't recite what that stands for, but to get what that rate is for any particular time, you can go online, look up LIBOR rates, historical LIBOR rates, Google, you'll get a couple of different sources of what LIBOR rates were for a given period of time, and you can check to see what that LIBOR rate is. I'm forgetting what it is right now, if it is in the 3% range right now. So that's the index. That's what you're going to start with to calculate the interest rate after it adjusts. Then in paragraph 4C is the method of calculation of change, which includes what we call the margin, the amount that's going to be added to the index to come up with the new interest rate. And in this case, as it says under 4C, the note holder will calculate my new interest rate by adding 6.4% to the LIBOR rate. So every time this loan changes the rate, you're going to look up what the LIBOR rate is and add 6.4% to that amount in order to come up with a new interest rate. Now, what do you think the chances are that any of our homeowner clients understood this? 0. I'm speaking on behalf of my clients. I mean, it's hard for me to understand this. LIBOR was at 6% at some time in 2007. And so if you think about adding 6% to 6.4%, this loan rate would have gone up from 8.65 to over 12%. That's the kind of change that was hitting a lot of homeowners in 2006 and 2007. The rates are a bit lower now, but chances are the new rate is still going to be higher than the original rate. And if you turn the page to paragraph D, you'll see the limits on the rate changes. And in this case, this is particularly onerous, that as of the first change date, the rate could not go any higher than 11.65, up from 8. So thank you very much for putting that cap on it for the first change. Usually they're a little lower for the very first change. And it can never go lower than the initial rate of 8.65. Subprime adjustable rates never gave the borrowers the option of taking advantage of lower rates, only the option of having higher rates. The maximum rate that this loan could get to was 14.65. You see that also in paragraph D. So partly it's good to understand this so you know where your client's rate is at the time that they come into, but partly it's useful to be able to put in your request for a loan modification. This is how awful this loan is. It can go up to 14.65. Let's bring it down to 6% and fix it. The next page, page 119, is a balloon rider. A balloon term in a loan, and there are decent loans with balloon payments, and then there are the rip-off subprime loans with balloon payments. A balloon payment means that the loan was amortized, let's say, for 30 years, but then cut off at 15 years. And as you can imagine, if you've made 15 years' worth of payments on a 30-year amortization, whether it's a decent interest rate or not, you still owe a lot of money. So a balloon payment is going to be one large payment of all of the rest of the principal that's due at some number of years less than the full amortized term of the loan. The balloon attachment usually is not part of the mortgage but only part of the note. The mortgage itself, on the last page of many mortgages, there are a series of boxes that can be checked to show if it's an adjustable rate, if it's a balloon note. So you might get an inkling that this has got a balloon payment by looking at the last page of the mortgage if you have access to that. But otherwise, you need to have the complete set of loan documents. I've never had a client who reached the balloon payment and that was the source of the problem. You may find people coming in now who reach the end of their 15-year balloon notes and they've got this one large payment that they can't now manage because they can't refinance. But usually the loans went into default because of the onerous monthly payment or adjustable rate, not because of the balloon. But it's yet another shock to the homeowner to find out that after paying for 15 years, I'm still going to owe this significant amount of money. The next couple of pages are prepayment riders. The whole mechanism of subprime lending and refinancing included prepayment penalties. It was pretty well understood that these adjustable rate loans would have to be refinanced after the 2 years. So hand in hand came a hefty prepayment penalty when you hit the 2 years, the first change date of the adjustable rate mortgage, and you needed to refinance because you couldn't afford the payment anymore. You would get hit with a prepayment penalty. On page 123 is a sample truth in lending disclosure.
Can I ask a question?
Uh-huh.
It's not. I don't see it in this note, but we have seen in many notes, not many, but in some notes, a default rate of interest. So that the rate of interest that you start out with is then increased to some enormous rate in the event of a default.
Yeah, I personally haven't seen that. That's a credit card trick as opposed to a mortgage lending trick.
We have
But I
seen it
do
in
understand
some
that they're out there.
I think Tony Soprano wrote that word.
Yeah. That's especially horrible. I mean, to have a default interest rate in a mortgage loan, that if you start missing payments, the rate is going to balloon up. And, you know, if a client with that provision is in my office, I really want to not just have them walk away with this loan. I don't want them to get HEMAP assistance and just get caught up with the loan. I'd really want to push. And I'd want to make that case one that I would stick by if it went into foreclosure in order to get rid of that. Because that's nothing but predatory. Truth in lending disclosures. We're going to talk a very little bit about the Truth in Lending Act in the afternoon. We would have to do a whole day on Truth in Lending Act to really get through the fine points of it. But every borrower should get a Truth in Lending disclosure. The key information disclosed are up there in the 4 blocks at the top: the annual percentage rate, the total finance charge, that is, if you added up all of the interest paid or that would be paid over the full term of the loan, plus all the fees and costs paid up front that count as finance charges, this is how much finance charge you would pay over the life of the loan. That number alone should stop most of us from ever signing up for mortgages, good or bad. It's just a very large number. The amount financed is intended to be the amount that the homeowner got the benefit of, with a couple of exceptions. Some of the fees can be left out of the amount financed. And then the total of the payments, if all the payments were made for the full life of the loan, what would that sum be? Beneath that, the payment schedule. This is where you will see, if it's an adjustable rate, if you haven't seen that in anything else yet, you'll see there are some number of payments that are made usually in the first 2 or 3 years, and then a change is indicated, usually a higher payment, and then one final payment. If there's a balloon feature, you're going to see one very large payment listed in this section of the Truth in Lending disclosures. There's additional information down below, but the key information is that block up at the top. The next page, 125, is a sample notice of right to cancel. The Truth in Lending Act does give an opportunity to cancel a loan that's secured by the borrower's primary residence, that's not a purchase money mortgage. And again, we're going to talk a little bit more about this in the afternoon. Every owner of the home, as opposed to every borrower, every owner of the home is entitled to a notice of right to cancel. So if there are owners of the home who are not also borrowers, those owners should have received a notice of right to cancel if that property is their primary residence. There are sections on the form for dates to be filled in. Those dates must be filled in. You can see here there's the document signing date as a blank for a date, and there's a handwritten date, and then final date to cancel below. I hadn't seen very many errors in the notice of right to cancel, but somehow in the last couple of weeks I've seen 3 loans where I believe there's a right to cancel under the Truth in Lending Act. And again, we're going to talk more about that later. But it's important to have at least a minimal grasp on the Truth in Lending Act and this right to cancel, because it can be a pretty potent tool in your toolbox if it applies to one of your clients. The next couple of pages are additional sample settlement statements, and I'm going to just point out a couple of features on these. In the upper right column, and these, I guess these comments are more geared towards if you're going to end up litigating a case, if you're going to be in a foreclosure defense, or there's a case that's appropriate for actually suing somebody. But just so you understand some of the things you might find in a settlement statement, on the left side, line 812, there's a payment, $630, in parentheses, POC, and then YSP. First of all, the letters POC refer to paid outside of closing. And you may see that attached to a number of payments that are pretty innocuous, like the appraisal fee. Appraisal fee, POC, $300. That means that the homeowner handed a check to the appraiser to cover that cost. It's not being financed in the loan. But POC YSP refers to a yield spread premium. It's a payment that was made from the lender to the broker. And typically in return for the broker bringing the loan in at a higher interest rate than the homeowner would have been eligible for otherwise. Right? So you're financing a payment to the broker from the lender by increasing the homeowner's interest rate. I find this to be typically a predatory practice. I mean, there could be a legitimate use for it if the homeowner didn't want to finance the broker fee but didn't have the money to pay it up front and agrees to a somewhat higher interest rate in order to pay the broker up front by the lender. But I've never had a case where my client understood that and intended that and that's why it was being done. Typically in these loans, it's a payment to the broker in addition to a broker fee that was financed out of the loan proceeds. Just out of curiosity, up at the top, the right column, it states the identity of the settlement agent. Again, this identifies the party that did the loan closing, and it says place of settlement, just as a sideline. It often identifies an address where the loan didn't close. Most of the loans from my clients closed at their homes. And in some of these, you'll see addresses in other parts of Pennsylvania, in California. I'm pretty sure my client didn't travel to California to do this. I just find, there are little lies and there are big lies in these documents. This is one of the little bits of misinformation where the loan closed. The next settlement statement, the yield spread premium is what I mostly wanted you to see out of this sample. The next three settlement statements all come from the same homeowners and is a good illustration of what we call flipping, refinancings that happened one after the other in a relatively short period of time. And for understanding the predatory nature of a pattern of lending, it's very useful to have, if your homeowners, clients, have refinanced more than once recently, it's nice to have the settlement statements for each loan so that you can really see what the effect of that series of refinancing was. So in this first settlement statement, and just to talk generally about settlement statements, on this page 129, on the left-hand side of pretty much any settlement statement, there will be the fees that are included in the loan, with a total of the fees at the bottom. And then on the right-hand side, typically the amounts that are being paid on behalf of the borrower, including mortgages that are being refinanced, unsecured debts that are being refinanced. Then also on the right side, down towards the bottom, the total amount of the loan, a total of the settlement charges and the other disbursements being made, and then a block for disbursements to the borrower. So if your client was supposed to get cash out of the loan, that's where it would be listed on the settlement statement. And it doesn't hurt to always ask your client if he or she really got money. If the settlement statement shows some cash being provided to the homeowner, ask if they really got it. In this case, this loan date was July of 2005. Line 1502 shows that it refinanced a relatively small amount of debt that was left on a prior mortgage, $13,600. The total loan amount was $40,000, and they received $12,000 in cash, in this case to do home repairs. On the left-hand side at the bottom, it shows $3,600 in fees. The next page, page 131, shows another loan, and it doesn't have the settlement date, but it was July of 2006, about a year after the first refinancing. The very bottom of the left-hand column shows fees of about $4,800. On the right-hand side, it shows $30,000 being paid, line 1502, to the prior loan company. Total loan amount $72,250. So in a year, they've gone from $40,000 of mortgage debt to $72,000 in mortgage debt. And the year before that, they had $13,000 in mortgage debt. So it's gone from 13 to 40 to 72. And then the final, page 133, less than a year after the 2006 loan, another refinancing. In this case, on the right-hand side, line 1501, you see $75,270 being paid on the loan that just happened less than a year ago. That loan was for $72,000, so there's $3,000 probably in a prepayment penalty that's been added to the debt. Down towards the bottom, the mortgage debt is now $90,000. They got $784 out of this most recent loan. On the left-hand side, the bottom, the fees in this most recent loan were $4,400. If you add up the fees, all those fees summed up at the bottom of the left-hand column of each of these settlement statements, this household has paid out and added to the debt against their house about $12,000 just in fees. And they've gone from $13,000 in mortgage debt to $90,000 in mortgage debt in just a couple of years. And that's to me a sign of predatory lending. Now, what can you do with that in this most recent loan when you're trying to do a workout on this $90,000 loan? It's probably not going to help that much, but it's good to know it if you find yourself in foreclosure to point out that this was a targeted refinancing for a household that had already been through a couple of flips on predatory subprime loans. Again, at other sections in the materials, there are good summaries of loan terms. I mentioned a section earlier, also starting at page 215 in your materials. There are summaries of different kinds of adjustable rate loans that you might encounter. We in Philadelphia in legal services haven't encountered what they call exotic adjustable rate loans, like hybrid loans. On page 218, there's a description of what that is. Interest-only loans, negative amortization loans. Those are all described in this section of your materials between pages 215 and 226. The more complicated the loan terms, the less likely your clients understood what was going on, and that I would highlight that in your correspondence with the servicer to try to work things out